Welcome again to another episode of You and the Law. In this episode, we'll discuss the right to freedom of expression. It's provided for under Section 39 of the 1999 Constitution of the Federal Republic of Nigeria. Now, in the last episode, we looked into the right to freedom of conscience, thought, and religion, as provided in Section 38. Now, this right to freedom of expression is just an outflow. A thread runs through the right provided in Section 38 into the right provided in Section 39. Section 39 provides that every person shall be entitled to freedom of expression, including freedom to hold opinion and to receive and impart ideas or information without interference. Now, just as the other right, this is also not a Nigerian thing. It's not a Nigerian right. It's also provided for in numerous international instruments. Article 19 of the United Nations Declaration on Human Rights of 1948 makes elaborate provisions on the right to freedom of expression. The same thing with Article 19 of the International Covenant on Civil and Political Rights. Also Article 9 of the African Charter on Human and People's Rights. They all make very clear provisions on the right to freedom of expression. Now, subsection 2 of section 39 goes ahead to also delimit the right to freedom of expression. It provides that the right to freedom of expression includes disseminating one's belief in whichever way one deems fit. However, there's a suggestion, there's an exception, there's a caveat. The caveat is that for dissemination through the televisions or wireless network, there must be an authorization by the office of the President of the Federal Republic of Nigeria. Now, subsection 3 makes provisions that certain class of persons may be restricted in how they disseminate information. For instance, people holding offices under the federal government or state government, of course, they can be limited in the information they are allowed to release. This also extends to people in the armed forces or the police. There could be limitations on them to, of course, of course, we have to understand that the fundamental rights must always be understood in community with the rights of the entire populace. There mustn't be a trade-off between the personal right, that's the individual rights, and the right of the general public. So some of these restrictions on the disclosure of certain informations are based on public interest. Now, the section further provides that some restrictions might be placed to make sure that the independence and, of course, impartiality and dignity of the courts are maintained. There are also the restrictions that will make sure that information received in confidence are not divulged recklessly. For instance, information received by, of course, from people in where there's a fiduciary relationship, maybe from a medical practitioner and a patient, or a lawyer and a client. Such kind of informations are not readily, they are restricted in expressing or disclosing them. These are the subtle limitations to the right to freedom of expression as provided in section 39 itself. Now, as observed in many cases, the right to freedom of expression is at the heart of democracy. Now, in a constitutional rights project versus Nigeria, the African Commission made it very clear that the right to freedom of expression is vital for a thriving democracy. Also in Suleiman and Sudan, the court used the word that the right to freedom of expression is the cornerstone of a democratic society. Now, the expression of these rights, as we saw in subsection 2 of section 39, can take various forms. Now, the only limitation is that to own a television channel or a wireless network, it must be with the authorization of the president, except outside these limited circumstances. A person might choose to express himself in whichever way he finds, of course, convenient and possible in limited circumstances. We have seen people establishing newspapers. We have seen people protesting. Now, the court, the Nigerian court in Dean and Director of Public Prosecutions, made it very clear that a person, Dean and African Press of Nigeria, African Press of Nigeria Limited, made it very clear that a person can establish a newspaper, establish and operate a newspaper production outfit. Again, the right to protest is not just provided and protected in Nigeria. Many other countries made it very clear that their citizens are entitled to protest. That is, for instance, to bear placards and go to public places to protest whatever shortfalls or in governance or whatever discrimination or maltreatment either felt or perceived that they received from anybody. Now, in the United States, we've seen a lot of cases. Of course, the United States Constitution is very, very pungent. It's very clear in its mandate in the area of freedom of expression. The Constitution makes it very clear that the legislature does not have the power to make any law to curtail an individual's right to freedom of expression. And flowing from this very, very concrete provision of the Constitution of the United States, now the practices there have tended to move towards a libertarian understanding of the right to freedom of expression. Now, many cases have come up, but we'll just look at just a few of them. In Tinker and Des Moines School District, the court held that wearing of black armbands in protest of the war in Vietnam during the Vietnamese War was permissible. Now, students wore the black armband to protest the atrocities and, of course, even the presence of America at all in the Indo-Chinese region, in fighting, in prosecuting wars in Vietnam. So the government opposed the wearing of black armbands, but the court held very clearly that citizens, the students, have a right to wear the black armbands and to protest their dislike for government involvement in Vietnam. In Grenada and the city of Rockford, the court held that students this was decided in the thick of the Civil Rights War, that's equality, the racist war. I think it was in 1969, and it was a mixed school of both black and white kids. In that school, at some point, the black students organized themselves, both with their parents, relatives, and they organized the protest. They staged the protest in the front of the school, and some of the placards they bore, the inscriptions like "Black cheerleaders too," and also "Black teachers for Black history," which tells us that they wanted black teachers to teach black history instead of white teachers to teach white history. The government was against them, and the police were sent to disperse them. And when the police officers came with their microphones, they read out the provisions of there was an anti-noise law and an anti-picketing law. They read out those positions to the protesters, and then went and rounded up about 40 of them. Getting to court, the matter was that the charge against them was that their actions was producing noise and disturbing the students who were in school. But the court held that if there was anybody who was emitting noise to disturb the students who were in school, that it was the police officers who were blaring away in their loudspeakers and now reading out the provisions of the anti-noise law and the anti-picketing law. They noticed that all that the protesters did was raise their hands in a power to the people signal and bear the placards with the inscriptions thereon. And the court held that they had the right and their convictions were quashed on that ground. Now, coming down to Nigeria, the right to freedom of expression as provided in section 39 of the 1999 Constitution is not an absolute right. Of course, all over the globe, even the Declaration on Human Rights, the Universal Declaration on Human Rights, subjected the right to freedom of expression to certain exceptions. The same thing with the Covenant on Civil and Political Rights. But under Section 39 of the 1999 Constitution, certain exceptions were limited, in addition to the general exceptions provided in Section 45 of the 1999 Constitution. And the tenor of the exceptions are to the effect that, one, every limitation to the right to freedom of expression must be written. It must be contained in a written law. That's the question of legality. It must be the restraint, the limitation must be legally prescribed. There must be a law prescribing the limitation on the right to freedom of expression. Now, the courts have held that this limitation, this legal limitation, must, of course, be read to only include written laws. It does not include customary laws or maybe usages and traditions. It must be a law that was made specifically to limit the right to freedom of expression. Another question is the legitimacy question. Now, once a law has been made, questions must be asked further. What is the purpose of the law? And the law made it very clear, the Constitution made it very clear, that the only exceptions that the law permits are, one, the law must be in the public interest. It must be, one, reasonably justifiable in a democratic society for the purpose of public defense, public health, public morality, and public health. Now, this provision has within it bowels two exceptions. One is the purpose, the legitimacy of the purpose, and two is the proportionality. The question of being reasonably justifiable, other jurisdictions and some international instrument uses the word necessary, but our Constitution uses the word reasonably justifiable. So the question is, what the government has done to constrain the right to freedom of expression, is it proportional to the value of the right to expression? That is the question that is always asked, and that is the question of proportionality. So at that point is the court coming in, and there can be a general test for proportionality. It's a case-by-case determination. The courts, and this is contained in the United Nations comment, the Human Rights, United Nations Committee on Human Rights Committee. There are commentaries in commentaries number 24, 27, and 34. Makes it very clear that there must be individualized and particular restrictions on the right to freedom of expression. There can be a woolen, there can be a broad restriction. Each law that passes the second test of being for the public interest must also be proportional to the ills. For instance, if we are discussing the individual aspect of the right to freedom of expression now, the law that restricts the individual right to freedom of expression the object of that law must be judged with the value of the individual right to freedom of expression. And it is only on case-by-case basis that this judgment can be made. And this is what our courts, of course, are set up to do. Now, through the years, in the question of legality, there was a case, the DPP and Chikobi. This was a case that came immediately after Nigeria's independence. Chikobi had circulated a pamphlet wherein he decried the government as enemies of the people, exploiters of the weak, and oppressors of the people. And he circulated the pamphlet. Now, he was, of course, charged in court for sedition under sections 50 and 51 of the Criminal Code Act. At the trial court, the High Court found him guilty, found the charges proved, but referred two questions to the Federal Supreme Court then. The questions were whether the crime of sedition, as contained in sections 50 and 51 of the Criminal Code, can be countenanced, can be accommodated by section 24 and section 1 of the Independence Constitution. Well, the Supreme Court decided both issues on the negative, holding that the right to freedom of expression and the crime of sedition, that they are not mutually exclusive, that they both include each other. Even coming nearer, in 2015, a lawyer, Solomon Okedare, he took the federal government to court. It was Solomon Okedare versus the Attorney General of the Federation. He took the federal government to court to challenge the constitutionality of the Cybercrime Act of 2015. Of course, Section 24 of that law criminalizes every dissemination of an information that is judged, that are judged either offensive, indecent, or pornographic, and which intent is to annoy or to cause discomfort. Now, the plaintiff argued that the Section 24 of Cybercrime Law, Cybercrime Act 2015, it runs foul to the provision of Section 39 and Section 39 of the 1999 Constitution, which provides the right to freedom of expression. But in arguing the case at the Court of Appeal, it was Bubaje at the Federal High Court who held that the right to freedom of expression is not affected, that the crime provided for in Section 24 of the Cybercrime Act, the offence created there, does not in any way affect the right to freedom of expression. But at the Court of Appeal, the plaintiff appealed further to the Court of Appeal, and the Court of Appeal held that Section 45 of the 1999 Constitution and Section 37, which also provides for the right to privacy, the operation of those two sections made it above reproach, made it very, very clear that the offence created by Section 24 of the Cybercrime Act cannot be deemed to be unconstitutional or invalidated by Section 39. That there's also the right to personal privacy, that individuals have a right to their privacy, and you cannot send offensive, indecent, or pornographic contents to individuals in order to annoy them and claim that you have a right to freedom of expression. Now, these two cases betrays the mindset of the Nigerian court in areas of the right to freedom of expression. And of course, if you look again at the trends, right from both military era down to the civilian, up to the Fourth and Fifth Republic, down to the Fourth Republic, we have seen that the government's stance on the right to freedom of expression in Nigeria, it leaves a lot to be desired. Right from the Obasanjo regime, the heinous atrocities committed during the military era, we can consider that as bygone. But even through the civilian regime of Obasanjo, and that's President Obasanjo, right to this current administration, we have witnessed a lot of crackdown on the right to freedom of expression. Under President Obasanjo, there was the popular July 2003 protest on the increase of fuel prices. Now, we saw that nationwide there was a crackdown on protesters, which led to loss of lives, and even the international observers noted that most of the protests were peaceful until the government came in and brought in violence by, of course, cracking down on peaceful protesters. Again, even during the President Obasanjo's regime, we saw the protesters who went to the U.S. Embassy to protest the visits of the U.S. then President George Bush. The protesters went to U.S. Embassy and read out a 5-page letter to the staff of the embassy. And upon coming out from the embassy, about 40 of them were rounded up just away from the embassy and detained for several weeks just for their peaceful protest. Now, the courts have, of course, not Nigerian courts this time, but even African courts and the the European Court of Human Rights, they've held that. Why we are taking this into consideration now is that the government have always brought up the issue of national security as the reasons why they crack down on peaceful protesters. Now, the courts have held that national security is not just about embarrassing the government in power. It must have something to do with an aggression, a threat or use of force, or an action that affects the ability of a nation to respond to the threat or use of force. This is what the law has, of the Johannesburg Principle makes it very clear. And the United Nations Human Rights Committee, even though the Johannesburg Principle have not been adopted fully, but they've made reference to it, and the African Commission have relied on it, that national interest, national security is not just any action that embarrasses the government or that exposes wrongdoing. National security only comes in when the well-being, that is the territorial well-being of a country, is put at risk by the threat or use of force, or by, of course, trying to weaken the country's ability to respond to the threat or the use of force, either internally or externally. And this was the Johannesburg Principle. And so most of these justifications of crackdown on the right to freedom of expression on the basis of national security will fall far below, of course, the principles we have already set out. The principle of proportionality, which stipulates that every limitation to the right to freedom of expression must be considered on an individualized basis. It must be in particular cases, on case-by-case determination, not just a woolly appeal to a vague national security catchphrase. Now, other limitations to the right to freedom of expression include of course, defamation. Just as you have your right to express yourself, another person also has his right to keep his reputation intact. So you mustn't use your right to freedom of expression to affect another person's right to his own reputation. A person's reputation most times goes ahead of the person, and of course most times our reputations even live after us. So you can't use your right to freedom of expression to negatively affect another person's right to his own reputation. So there's criminal defamation and there's civil defamation, and these are limitations to the right to freedom of expression. We've also talked about the maintaining the dignity and independence of the court. So for instance, the dictates of fair trial is that when matters are in court, when matters are sub judice, there's a lot of tact in reporting matters are before the court. So for instance, when there are reckless reportage, or maybe false, maybe when court proceedings are reported in a manner that does not pass this test that we've listed, a contempt proceeding can be initiated. And so maintaining the independence and the dignity of the court through the instrument of the contempt of court is also another limitation of the right to freedom of expression. Now, there's also the right to privacy. We've already discussed it in the Solomon Okedare and Attorney General of the Federation. A person is entitled to his own privacy. We've discussed it in section 37 of the Constitution. Every person is entitled to his privacy, both his family life and his telephone communications. They are all protected under the right to privacy. And a person's right to freedom of expression cannot be used to encroach on another person's right to privacy. We've discussed national security. Now, these are mostly the recognized exceptions, limitations to the right to freedom of expression. Now, we can also look at the right to freedom of expression from the perspective of the individual's right to know. Now, just as an individual has a right to say, to express himself, he also has a right, that another aspect of the right to freedom of expression is the right of media practitioners, journalists, to broadcast, to disseminate information. As we have said, the freedom of expression is the life wire of democracy, which means that there's need for free flow of information and ideas. So beyond the media rights, that's the rights of media practitioners, the third aspect of the right to freedom of expression is the right to freedom of information. Now, this right has a checkered history in Nigeria, dating from 1994, when the Media Rights Agenda first presented a bill to the federal government for a Freedom of Information Act. Of course, that was in a military regime, and it was it was discarded unceremoniously. But it did not die. The dream did not die. The dream was kept alive, and during the Fourth Republic, the civilian era, agitations started again about a Freedom of Information Act, and that agitation also failed in the first session of the parliament, because both the House of Representatives and the Senate, the bill failed in both houses. Not until under the administration of President Goodluck Jonathan, it was in May 28, 2011, that the Freedom of Information Act was finally passed. It received the presidential assent. Now, Section 1 of that law creates an obligation for public officers to, of course, to keep data, to keep their information intact. Now, Section 2 creates the right to know. It creates the right for any person to seek and receive information from any public official. Those information that the public officers are obligated to keep in Section 1, the law creates a right for every citizen to seek, to request, and to be obliged with those information by any holder of such information. Now, there are certain exceptions to the right to freedom of information. That's the Freedom of Information Act, and they are provided in sections 11 to section 19. These sections provide exceptions in situations of national security, also for instances where matters are in court or where matters are still under police investigation. That's for law enforcement agencies, because disclosing some information might betray the tactics, the strategies in use by some of these law enforcement agencies. It also protects certain information, for instance, research and examination questions. Of course, it doesn't make sense that a person will apply for the questions to be asked in an examination. So these are the limitations to some of these rights, and they are provided in sections 11 to section 19 of the Freedom of Information Act. Now, sections 20 to 25 provides the right of every person who requests for information to go to court if there's a refusal to honor the request. Now, once a request has been made, the agency, the officer who is to receive receives the request has two options: either to deny and give reasons. He can only give reasons for refusing, or once he denies the sought information, the applicant, the person who requests, can now go to court. And on going to court, there's a fine of 500,000 naira for the person who refuses unjustly to release information to members of the public. Now, Section 27 of the Freedom of Information Act protects public officers from disclosing information. These are information before which were restricted by Official Secret Acts and many other laws, the Criminal Code Act. These laws restricted the flow of this information, but this Freedom of Information Act protected any public officer who releases this information. And judging the journey so far, we can see from the antecedents, what we've seen in Nigeria, that even though Nigeria still has a long way to go, we have yet to test a lot of the provisions of many laws and many practices under these headings of the right to freedom of expressions. But we feel that Nigeria, we have made a lot of progress from just the recent past of military dictatorship, and a lot of voices are rising, even though the protest, the EndSARS protest of last year discloses a lot of very, very horrible mindset of people in authority. But we are seeing that people are rising up to challenge a lot of these actions of people in power, to include any disclosure of information that embarrasses the government, to tempt them national security questions. And of course, we are making progress, and we believe that as these matters are tested in court, there's a room for a lot of improvements. And we believe that in the course of, just if the civilian era continues, with the Freedom of Information Act and the general excitement and feeling of freedom of the members of the public, a lot of these laws will be tested, and as they are being tested, we will have a more robust idea field and information, a free information flow in our societies, which will make for a better democracy. We thank you for joining in this episode. We urge you to join us next time. Thank you very much. Have a blessed day.